Starting today's discussion, I would just like to share the screen. Just allow me a second. Okay, I hope my screen is visible to all. If any of the participant can kindly confirm that my screen is visible to all.
Yes, ma'am, it's
Yes,
visible.
ma'am.
Yes, visible, ma'am.
Thank you so much. So as we all know that IBBI from time to time come up with some discussion paper, some circular, some clarification whenever it comes to any kind of procedural gap or understanding or any kind of difficulty that has been faced by the insolvency professionals. So they come up with the type of changes that is required in law from time to time. And this time again, they have come up with a discussion paper. So to begin with, it's just a discussion paper, not yet implemented. So there are 4 proposals that has been placed by IBBI. This discussion paper came on 16th February 2026, and the last date to submit the submissions, if we have any regarding the proposal that has been made, is 10th of March. So I would request all the participants to, based on their practical experience, if they have any submission, anything to contribute regarding the changes that has been proposed, may kindly come up with the suggestions so that accordingly we can make suggestions regarding the procedural gap or the changes that we actually need, or if at all there is a gap wherein in the proposal that has been made. So would request the participants to be interactive and accordingly make the discussion a bit fruitful. So now coming to the main discussion of the topic today, which is regarding the proposals that has been made. So the proposal primarily consists of 4 changes. 4 changes are, if any of the participants have gone through with the discussion paper, so the changes that has been proposed are mostly clarificatory in nature. The basic requirement for the purpose of this discussion paper is to strengthen the deliberation of committee of creditors and of course to fill some procedural gap. So there are 4 changes, as I said. First is regarding strengthening the recording procedure of CoC while approving the resolution plan. So as we all know that CoC is required to record the feasibility and viability of each of the resolution plan as to on what basis they have considered a particular resolution plan or on what basis they have not considered any of the resolution plans, etc. So in this regard, now the changes that has come up or that the proposal has been made is to record or to deliberate in detail as to on what basis they have considered the viability of a particular resolution plan. Now, there are several other factors as well that is required to be considered by CoC, which is regarding the expected recovery for the creditors in comparison with the fair value and liquidation value determined under Regulation 35. What is that? So, as we all know that during CIRP, the RP is also required to prepare an information memorandum, get the valuation done of the assets of the company. So in that valuation, they get the fair value and liquidation value also determined. So now the concern is regarding detecting as to if in a particular plan that they are accepting or they are recognizing a particular plan, in that plan, what is the expected recovery for the creditors in comparison and they have to compare the same with the fair value and liquidation value. The second thing is also regarding the adequacy of market discovery. So they are also required to discover the market and to see the viability of the resolution plan that they are accepting. And they are also required to check the capability and credibility of the respective resolution applicant. The idea is that this should not happen that today I'm selecting one resolution applicant and say suppose I'm rejecting the other one. And tomorrow it come up that the particular resolution applicant to whom I have selected is not in a position to make payment towards the bid that he has made for the resolution plan. So they are also required to check the capability and credibility of the resolution applicant and the certainty of implementation of the resolution plan. So we can say that the task of insolvency professionals have been increased a bit so as to require them to make a more elaborative minutes or a more elaborative thing to be placed before the CoC, such that CoC can consider those factors at the time of considering a particular resolution plan. Now, these are the proposals. The proposal require the COC to see all these things. As we all know that whenever it comes to deliberation before the COC requires a hand, and that hand is the insolvency professionals. So ultimately, the task or the burden of preparing all these reports will be on the IRP. It's not the COC. That you cannot expect the COC to sit and prepare the entire plan, entire thing, check the validity, etc. So these checking tasks, etc., has to be done by the IRP or RP as the case may be, and accordingly is required to be presented before the COC, such that the evaluation work will be of COC. COC will ultimately evaluate the things. So while the provision says that the committee shall record the deliberation on this part, but for recording the deliberation, there has to be a proper basis on which the deliberation will be made. And this basis has to be provided by the IRP or RP as the case may be. So ultimately, yes, Devangji, I'm just coming to you for your views. So ultimately, the burden is on insolvency professionals, we can say that they are required to make more deliberate presentations before the committee of creditors such that they can record the deliberation while approving or rejecting a resolution plan. There are several questions as to how to record these deliberation, how to make the presentation, on what basis this credibility or capability will be checked, etc. So there can be several concerns. I'll deal with those concerns. So before dealing with that, I think we can invite comments from the participants at this point. Devangi, you were saying something. You may kindly unmute yourself and say.
Madam, the resolution professional is not supposed to speak on any commercial aspect of the plan. So even if the viability and all these things are there, it is COC who has to study and discuss, not the resolution professional. He just has to record the things in my understanding. Because in past, whenever on any commercial aspect, resolution professional has deliberated or spoken, it has resulted in investigation of STN to be issued. So maybe in my humble understanding, viability and all is the commercial aspect, which has to be seen by COC, only recorded by RP. No analysis of RP is supposed to be placed over there.
Devangji, with all due respect, I would just like to place a practical scenario before you. Like the committee of creditors are comprised of different financial creditors mostly. Hardly there are operational creditors, so there are only financial creditors that comprise of committee of creditors. And those who have practically seen as to how the committee of creditors discusses the matter, they all know that the representative of respective banks or NBFC attends the meeting, and they usually depends upon the confirmation that they will take from the ultimate authority and make representation before the committee at the time of taking any decision. So they always say that I'll come up with this discussion, or I'll come up with the final view on the matter from my team, etc. Or they, if they have the authority, so they discuss certain part during the meeting. But if you expect the committee of creditors to do the due diligence or to do this kind of credibility checking of the resolution professionals, etc., which means that we are expecting the committee of creditors to do this kind of change, this kind of observations or this kind of credibility checking, etc., which I don't think so that committee of creditors will do. So whenever committee of creditors meet, they meet and discuss on the basis of the reports that has been placed before them by the resolution professionals. So ultimately, the resolution professionals receive the things, they evaluate the things, they make all the required arrangement before the committee of creditors and place the same before the committee of creditors. The COC is ultimately is required to consider the same, to vote, and based on the majority of the voting of the COC, the respective resolutions are considered as passed or not. So this is the kind of approach that has been taken at if we see the deliberation part of the COC. But practically, just imagine this scenario that you are expecting the committee of creditors to make this kind of reports, etc. Who will make the report? Ultimately, who will be there to prepare the report, to evaluate the things, etc., to check the credibility? Who will check the credibility? Are we saying that the COC members will check the credibility of the respective resolution applicants individually? So, what will be the measure to do that? Yes, Devangi.
Madam, it's not just 29A, and even for 29A, COC has its own legal team. The SRT Chief Judgment clearly says that IP may make, but it is the duty also of the CoC to do due diligence. And I'm talking of commercial aspect of viability of plan, etc. On commercial aspect of viability, what has to be done? What is the differences between 2 plans, 3 plans, 4 plans? That is completely the domain of CoC. IP has got nothing to do into it. Which plan should be taken and which plan not to be taken. And even in my understanding, the SRC judgment is clearly there. Although IP will do the duties, but even the banks and financial institutions have their own legal teams, and it is their work to check into the things. They cannot simply put the blame on RP. And if they are incapable to do so, the concerned officer who is capable to do so, as per IBBI circular and take decision, has to come to the meeting. So this is my humble understanding, madam. Thank you very much.
So you have correctly outlined this part, that of course how to implement this part. While the discussion paper deliberates on this front, that these are the required things that are required to be deliberated by the committee of creditors while checking the validity of a particular resolution plan. However, they also require to mention in detail as to what are the aspects that they have evaluated, the credibility of the respective resolution applicants, their ability to make payment towards the bid that they have made, etc. So the thing is that what will be the practical approach to give effect to the same? I think the clarity is needed on that front as well. That should also be clarified as to how practically the same has to be given effect to. I would request other participants, if they have any view on this part, they may please unmute themselves and accordingly make submissions.
I quite agree with Mr. Devang Sampath's views
Yes,
in this
sir.
matter. Well, don't mistake me, but this is why I quite agree with him. Because
Yes,
RP is only a person who is holding the baby, who is holding the company when it is in the corporate insolvency resolution process. But as was he can give the inputs, he can only do the not inputs, not even the inputs. He should not even give the inputs for RA. But only thing is, he can, he should not even facilitate, if you ask me. It is only to the sole discretion of CoC. That is my take on that. I quite agree with what Mr. Sampath said earlier.
yes, sir. This is absolutely correct that it is a discretion of the CoC. It is the discretion of the CoC. RP has nothing to say here. That is for sure that RP has nothing to say here. But the ultimate presentation with respect to evaluation, in my view, is required to be made by RP. So RP is required to assist the CoC with respect to whatever documents, whatever.
Those things I agree. In case of
Yes. So
validation,
that
all
is the
that I agree. But here, instead of the board of directors, CoC takes the assumes that superintendent's role, and RP is only the executive. That's it.
right.
I agree with
Absolutely
you.
correct. Absolutely right. So that is the main thing, that while the proposal now points out on this factor that we are required to, the committee of creditors required to make deliberation on these fronts. However, who will take the task, or who will lead the thing, or who will make all these things prepared for the CoC? A clarity in this regard should also be there while making the changes in the regulation in this regard. Like whether, if say suppose, I think there's a background noise from somebody. If ICSI team can kindly look into the same and mute the respective participants.
But my take is, if you're going to
Yes.
go for every steps, don't you think it
Right.
becomes very tight? It will not be
Sir,
flexible, isn't it?
if you
I'm just
see the
my
very
view.
first part of the discussion paper, it says that the very idea as to why they are bringing this particular kind of change is to keep a parity between the practices of respective CoCs with respect to deliberation or with respect to acceptance of resolution plans. So the idea is to keep a parity. If it is about keeping a parity, so certain clarity in this regard, that how this deliberation is required to be recorded, to what extent the deliberation is required to be recorded. If say suppose I'm recording to some front and some front I'm not recording, will that make the resolution plan invalid? Certainly that should not happen. Second thing is regarding this expected recovery mechanism to check. So what will be the mechanism to check the expected recovery? What all factors am I required to look into while considering this part of expected recovery? Then the thing is regarding the adequacy or of market discovery to be determined. So how this adequacy will be determined for the market discovery? Will I see the similar kind of uh, companies who are engaged in similar kind of practices and then will evaluate based on that? So what will be the evaluation point? On what basis I will evaluate this market discovery is to be done on what basis? So this basis of market discovery is also a thing that requires clarity on that part. Then what is the standard of proof of establishing availability of fund? If I'm saying, say, suppose there is a resolution plan, there is a resolution applicant, and that applicant has come up with a certain bid, and I'm required to check as to if at all that particular resolution applicant will be able to make payment tomorrow or not. So at the front, what are the factors that I require to consider to see that the person has the liquidity, sufficient liquidity or sufficient amount to make payment? Because payment is not such that I'm required to pay upfront altogether. It's like periodic, there can be periodic payment as well. That they will make payment of certain parts today, certain parts tomorrow, certain parts after 1 or 2 months, like that. So that will depend upon the implementing agency to determine as to whether the resolution plan is running in the way that they have accepted or not. So, what are the factors that I'm required to consider at the time of considering the viability of the resolution applicant, like that they have the availability of fund? So if certain guidelines on this regard can be provided, so it will be helpful for the respective resolution professionals as well to keep a parity. That is what, in my view, the suggestion should be. Rest, of
Ma'am,
course, the
ma'am, there is
participants
evaluation
may.
matrix. There is
Right.
evaluation matrix for the same. So what else is required? Because I think for evaluation matrix is the base, and on that basis, resolution plans are being evaluated. So, is there anything being proposed that there would be some more requirements to evaluate our resolution plan for the comparative analysis of the resolution plans, or uh, uh, already there is evaluation matrix? What else is required?
So, Ranjanji, are you saying that there is no need of this change that has been proposed?
Yes.
Okay. Is there any other view of any other participants in this regard? Yes.
Yeah, there is a already because everything as far as the resolution plan is concerned, the same need to be evaluated by the COC with respect to even the evaluation matrix. Everything is approved by the COC before a resolution plan is invited, and even whatever the with regard to recording of things, the minutes are after the meeting, every meeting minutes are circulated among the COC members. And if they have any divergent view or different view, or they want to add, they always give their opinion. So everything is, since the insolvency itself is driven by, it's a creditor driven insolvency, so the opinion and the decision and evaluation of the creditors matter, not the RP and anybody else.
To some extent, I also do agree with Harvinder ji on this part that yes, uh, like something we are also required to leave it up to the COC to determine, because there are several factors that we have already provided in the law to evaluate the resolution plans. Now, if we'll factor these things as well, and if we add on further things, so I think that will just create some kind of burden on the resolution professional only and not on the COC. And to what extent that the deliberation is required, to what extent these things are required to be recorded, etc. I think some metrics can be provided in that regard if at all needed. However, the changes, if at all IBBI is thinking to bring the changes, then with proper clarity, those changes should be introduced. Other participants, if they have anything to say in
Yeah,
this
there
regard,
can be SOPs for evaluation or the decision taking process on the resolution plan that can be standardized, and SOPs can be developed and approved.
thanks. Thanks. Anyone else has anything to submit in this regard? If they have any views on this, whether this changes is required, to what extent the same should be considered, and if at all the changes is not appropriate, then what all changes should be introduced here. So if they have anything to submit, any of the participants may kindly let me know. Then accordingly we will move ahead with the next changes.
Understanding, a compulsory code of conduct for CoC is required. Of course, the second amendment also says so. And CoC has to be held responsible for whatever they do or whatever they say. RP cannot be made responsible for CoC. If it's their duty and their domain, they have to do the hard work and they have to do responsible for their decisions. A code of conduct is required, in my understanding, for their actions. You cannot have authority without responsibility.
Any other submissions?
Hi, Miss Barsha, this is Kanak here.
Yes, Kanakji.
Actually, of course, I'm in agreement with whatever sir is saying. Besides that, see, the CoC ultimately are the beneficiaries out of the entire process. So they are the rightful people who actually can determine whether this is feasible, not feasible, and whether the party is capable, competent, not competent. In fact, they have a whole lot of a machinery to determine whether, there are the resolution applicant is eligible, ineligible, or anything in terms of the credentials of the SRA or the PRA. So in fact, they should be equally responsible. In fact, somewhere as an individual RP, whether it's an IP or an IPE, they do lack the machinery because they're not really financial institutions. So they may not have as much of information that the CoC may have. Because considering most cases, the CoC is formed by the financial creditors only. So they are the rightful people, in fact, to determine whether, the resolution applicant is competent enough and will ensure that the plan is implemented. Besides that, when it comes to implementation stage, also there should be some responsibility even on the NCLT where there have been resolution applicants who failed to get their plans implemented. There has to be a separate list prepared where an RP can actually look into for finding out if there's a defaulter in implementation of a resolution plan in that particular list, which presently is not available. So yes, there has to be some responsibility which also goes to CoC, and equally, before the NCLT also, if they can prepare, so NCLT or IBBI as the case may be, there has to be a separate list which can be referred to for all these defaulters and non-implementation of plan. Of course, this is my input on this.
I
I
think,
agree
ma'am,
with
we
Kanakji
can
as well on this part.
we can
Yes,
go
yes.
with the 1 to 9 points. That is the first point. CoC's commercial wisdom is supreme. That can't be challenged. And number two, will non-recording or insufficient recording in every for every meeting. RP is circulating the minutes, and that minutes is generally being adopted in next meeting. And three, what should be the method for calculating expected recovery? This would make more confusion and more burden on the resolution professional. Sir, because there are expected recovery, there are many methods, net present value, IRR. So what the method will be adopted? And number four, how is the adequacy of market discovery? Market discovery is a very judgmental thing, ma'am. And how this market discovery that CoC can determine, and what RP will do with that, because most of the companies are coming into CRP. Those are actually seek or not. Most of the 75% are not going concern. So, market discovery is a very similar type of industries will have to be checked whether the situation of the company is same. That is, it will make more confusion, I think. Number five, how will the capability and credibility of the resolution applicant be judged? That is the 29A and other already there. So, what is the need? Number six, should there be a minimum number of resolution plans be called adequate? This is how can it be? Because most of the companies are sick. There may be 20 PRAs, but there may be two or three SRAs. So who are submitting their resolution plans. So number seven, whether opting for challenge mechanism a mandatory requirement in all the cases. This is more vague. I think what is it? What is the meaning of this? I can't understand. What is the standard of proof for establishing availability of funds? We can see that there are many cases resolution applicant are bringing resolution applicants are bringing strategic partners. So what is the need of this? What if the CoC records certainty of implementation but the resolution plan subsequently fails? What if the CoC records certainty of implementation but the resolution plan subsequently fails? It depends upon many situations, which is unforeseen. So I think it will make more burden on the RP, and it will make the things more to guess upon on the things that are being proposed. The existing framework of evaluation metrics is good, and 29 is there, 29A compliance, and there are other compliances also that are like already there are many things, many compliances for this. So I think this will make the things more discretionary. So it will make add confusion in the process. Already RPs are
I think
So,
fully assigned.
Madam
Ranjanji,
should
I'm sorry, I'm
respond.
just
He has
stopping you in
already put
between.
across his point of view. I think Madam should get time to explain.
Yes,
Thank
yes.
you so much, sir. So actually, Ranjanji has made my task easier. So these are the potential questions that arised in my mind while I went through with the discussion paper, that these are the potential concerns. And while IBBI is putting forward with some kind of changes that they want to establish a parity. However, at the same time, I personally believe that they should provide a clarity on how on this factor as to how to practically the same will be possible. What practical factors are required to evaluate these things. Just merely putting changes in the resolution in IRPCP regulation will not help, because we all know that IBC is all about practical experience. All the cases differs, and when the very idea behind making the changes is to keep a parity, then some kind of SOP or some kind of particular metric should be there, so that that can be considered in mind while putting the deliberation in writing. So the very idea, I think, behind this changes is to keep on record on the detailed deliberation on this front as to on what basis they are evaluating the resolution plan. Why so? Because it has also been seen in some of the cases that CoC has given preference to a particular resolution plan over other plan, and ultimately that resolution applicant has failed to commit or to make payment towards the ultimate bid. So this has also been experienced in several cases. Maybe because of that, this changes has been proposed so as to deliberate in detail that proper evaluations were done before accepting a particular plan. The viability and credibility of the resolution applicant was also checked, that that person has the capability to make payment, and that the market factors were also evaluated, and relative comparisons were also done while accepting a resolution plan, because it is about a plan. It is not just that today someone come up with a particular proposal and tomorrow that person says that I'm not in a position to make payment, or for some or the other reason I'll take my step back with the resolution plan, so that the entire thing will start from zero again. So maybe with this approach, this changes has been proposed. However, the language of the resolution or the changes are such that requires a proper clarity on how to give effect to the same. So a clarity in this regard, maybe by way of a metrics, maybe by way of a SOP, should be provided so as to keep a parity, so as to keep it clarity for all the resolution professionals as to what will be their duty and what will be the duty of the committee of creditors. That is what is my understanding. However, there are
May I?
other senior members as well. If they have anything to say, may please.
Thank you. This was really worthwhile discussion. I'm Mamta Binani here. Just wanted to
Yes,
add a
ma'am.
point, a supplementary point that, like for example, you have a IBA matrix, Institute Banking Association matrix for evaluating the plans. So, more or less, we see that in 99.99%, that is the matrix, that is the evaluation matrix that is being used. One which is the IBA format. It is I think going to be very worthy this in this proposition if in the regulations we also get some kind of a, though the evaluation matrix is not given by the IBBI in the regulations, but somewhere or the other a guidance will be required, or a guidance note may be floated by IBBI for the purposes of discussion on viability and feasibility. Let me just take a minute more to say that today, when we see feasibility and viability study being made by the COC, it is anyways, it's just a exercise which is more on the paper rather than doing justice to that exercise. Hardly, 5 years figures are given that my business, if I take this up, will look like this in the next 5 years, and I will be making profit in the third, fourth, and fifth year. In the first 2 years, there will be no profit, and therefore the COC just kind of looks at it cursorily and say that okay, it is viable and feasible. So I think that the ministry, the IBBI is trying to curtail, which is a very good step. So therefore, I feel a guidance note should be at least floated, if not coming in the regulations.
Thank you so much, ma'am. And now that we have Mamta ma'am in the house, who's having such a vast experience when it comes to CIRP, ma'am, I would also like to hear from you on this part that they also have proposed regarding the estimated market evaluation on this front. So,
Yes.
do you think that we should also have a criteria or a SOP for the purpose of on what metrics or on what basis the market evaluation is required to be done in this regard?
Yeah, true. We should, because this will actually kill all the litigations. But this is very difficult. I mean, if you really ask me, there's not much time. In 15 days, you get EOI. Last day EOIs come. You give a month for a resolution plan. I don't know where we will get the time to actually say that the adequacy of market discovery, now we are saying that it is adequate. So I don't know how to really do this in practicality. It is a very, very difficult process. And every day, believe you me, the market changes. आज कुछ है, 2 दिन बाद कुछ और हो जाएगा. Say, for example, a road just is sanctioned by the government that a main road is going to go through this land. Immediately, the price changes. So every day, it is transitory in nature. So how will you really understand that market discovery has happened adequately? So I
In
think
fact, ma'am,
something
some
like
of
this.
the,
Yeah.
I'm sorry, I'm just cutting you in
Yeah, please
between,
go ahead.
ma'am. Some of the members were also saying that this should be the responsibility of COC and not the resolution professionals.
Yeah, I heard
However,
that.
I believe
Mm.
that you might have also practically seen this thing that COC is working based on what we serve before the COC. We cannot expect COC to do any kind of evaluation or any kind of representation or any kind of market chase up of their own. They will depend upon the task to be performed by the resolution professional, and they'll just evaluate based on whatever's been served by before them by the resolution professional. Is that so, or we can expect COC to do this kind of evaluation and based on that to
No, I think this is so much a commercial wisdom domain. I mean, why should the COC should discuss, and maybe we will monetize it. And when we monetize with the full responsibility, very humbly, I'm saying to each one of us, including myself, that sometimes I appear as an arguing counsel in the NCLT and courts. I have seen our minutes are very scanty. Such things which has come here is generally noted by the RP in the minutes in vivid letters. But where we falter sometimes is because we are not having the minutes, which is quite substantial in nature, which could prove that we have actually gone through it. So, just to handle your question, I think it should be in the COC domain, and we should monetize that. Yes, COC has explored with the help of RP on adequate market mechanism.
Now,
Should
I
be a
think
COC
the
domain.
eligibility part should solely lie with the RP. Uh, correctness of claims, the capability to pay, etc., and the other part can be uh, decided by the CoC.
One of the members also submitted in this regard that the financial creditors and the CoC members, they are more equipped with this factor to evaluate the credibility of certain certain resolution applicants rather than the resolution professional themselves. So if that part is also evaluated by the respective CoC members, that the particular person who has come forward with a plan has a particular credibility or is capable of making payments, so I think that will be better in that regard. So with this, I think we are good to move with the next proposal.
May I add something?
Yes, sir.
Actually, regarding the first two or three, I do agree that a resolution plan should not be valid unless and until properly recorded and properly maintained. But if the resolution plan approved and the resolution applicant subsequently failed to deliver that agreement, then we should debar that person to re-venture again in any of the resolution plan, in my opinion.
So I think that is otherwise as well as there also, that if a resolution applicant particularly fails to obey the plan that they have submitted, then in the subsequent invitation, they will not be given the
yes,
chance
not only
to make
these companies, also all these companies, prospective applicant for all companies, that applicant should be debarred
from making submission or
yes,
submitting plan in
not only
any
these
of the
companies, all the other companies.
So there has to be a database created of such defaulters, is what we were discussing.
Yes.
Madam, may I speak something? Madam, may I
yes,
speak?
yes, sir, yes, sir, please.
Madam, if you see the old regulations, where the regulation says CoC has to record its deliberation on feasibility and viability of the resolution plan. If you look at the meaning of what is the meaning of the feasible and viability, to my mind, as a financial professional, feasibility and viability means financial viability of the project. And when you see the word feasibility, it connotes two meaning. One is the managerial capabilities and financial capabilities. So it means when the CoC records his views on the feasibility and viabilities, they have to deliberate and record all these findings. And now what is the proposed regulation? It seems to be mere a further clarification what point it means when we talk about feasibility, viability, what it means. Now, second question is, yes, it is a fact, hard facts. CoC never deliberate adequately on the feasibility and viability of the resolution plan. In most of the cases, RA does not submit any financial projections, never submit IIR or the financial. What is the financial ratios? I hardly find any plan which contains the financial ratios which shows the plan is viable. And second issue is the CoC members who are sitting there in the CoC are competent to evaluate the feasibility and viability of the resolution plan. Normally in any bank, feasibility and viability of the resolution plan is a detailed process which is carried out by the project department or financing department who has the specialized education for that one. But when we talk about the CRP, only stats department people attend the CoC meeting. Do we expect they will able to carry out all the entire feasibility viability aspects and record adequately deliberation? Number two, suppose if CoC does not record all these aspects what has been stated in the proposed amendment, what is the RP's responsibilities? Will the CoC will be responsible? or will the RP will be responsible for this? RP's role is to put up the plan before the CoC, which is found compliant. And once this regulation is under the CRP, CoC's domination, it means RP has to evaluate the plan in compliance with the other regulation, not these regulations. It is the CoC domination which has to deliberate on this point. Now, how RP is responsible if CoC fails to adequately deliberate on these points, does not record, will this plan will be considered non-compliant? And how this will be happened? Then who will be responsible all these things? Now, if you see the sources, in most of the plan, you will hardly find adequate sources. Why? Nobody is able to suppose it's a 100 crore plan. Will anybody be able to demonstrate he's having the 100 crores? Certainly not. Even if you say the financial letter and a comfort letter, it is normally not binding letters. I am also the resolution professional. We are handling so many cases. Hardly there is any plan which are sources are fully demonstrated. Now it is a calculated call on the part of the CoC. Even the RP in today's junctions, RP had to give the mandatory compliance certificate. Okay, yes, this plan is compliant. Where sources is the main issues. How RP handles those issues? In many cases, we have said to the CoC, we are not fully satisfied with the adequate resources, and then let the CoC should deliberate and confirm this plan when RA has the adequate sources of the fund. And in 1 and 2 cases, CoC backtracked and they appointed a new agency, an independent agency, to evaluate this person. RA has the capabilities, financial resources to implement this resolution plan. So this is the way we have to say in the regulation. This is more clarification how the RP will ensure, how the CoC will ensure if the CoC has conducted the negotiation, how the CoC will say, okay, I am not able to conduct the negotiation fully. I am not done adequate precaution and maximize the value. Can the CoC say? Certainly not. So what these regulations mean after all? This is my submission on this and a second proposal. I am not able to say anything on my first proposal. In the first proposal, there are 2-3 inadequacies also when they talk about the approval of the CIRP cost. The first regulation does not define what is the meaning of the going concern.
We are
Absolutely.
yet to discuss on that front, sir. We are still on the first proposal only, which is regarding the resolution plan. So we are yet to see the second one, which is regarding the CIRP cost. Just
Yes.
allow me some time. I'll just quickly move to the second proposal. Then, of course, you may put forward your thoughts on that. Right. So coming to the next one, the next proposal, which is there. So it is regarding the CIRP cost. So as we all know that cost associated with the CIRP process will form part of the CIRP cost, and what all will form part of the CIRP cost and what all will not form part of the CIRP cost is to be determined by the Committee of Creditors. Now, just to put a clarity in this regard, the provision now says that this entire task has been divided into 2 parts. First part is from the inception, from the insolvency commencement date till the time the CoC is in form. So till the time whatever expenses will be made, all those expenses are required to be placed before the first CoC meeting and certainly will be ratified by the CoC. And thereafter it says that estimation of the cost to be incurred in the near future or for the next quarter is required to be placed before the CoC, and what will be the estimation of cost and what actual cost has been incurred. So that comparison is required to be placed by the resolution professionals before the Committee of Creditors. That is also is a part of this particular provision, this particular changes that has been proposed. So I'll just quickly move to the basic changes that has been proposed as a part of the CIRP cost.
Madam, I'm just interfering in between because it relates to earlier point. I apologize for the same. Ma'am, when we are talking, as it has been put earlier, that even earlier the regulations were there that we had to record. But the CoC never discussed the same. Plans were put to e-voting. Even the officers sitting did not know what the e-voting is going to happen. And the e-voting would be open for 1 month, 2 months, and sometimes even after 2 months it has not been voted. So, then the how these are difficulties. Maybe the regulations are so, but if the CoC
Sir, your voice is not coming clear. I'm sorry, we are unable to hear you properly. I think let's move to the next proposal, and then if Mr. Devang will want to say anything, we will hear.
Can you hear me, madam?
Yes, it's better now, sir. You may
Okay,
please.
madam. Madam,
Yes.
even the regulations were there earlier, but what used to happen is a number of plans were being put to vote, and which plan is going to be voted was not even known in the meeting and to the officials. It would be kept open for e-voting for 1 month, 2 months, and sometimes even after 2 months not voted, e-voted. So even when the official, junior official sitting in the meeting is not aware what the decision is going to be, how will the reasons be recorded? This is the issue even in the past, and if this is being extended in future, maybe some, first of all, there are some great bankers also, very senior, very learned, great bankers. So even amongst them, there is a mixed bag. It's not that all are good or all are bad. Like in our professions, even over there. But generally, we see that very junior officers who are not aware, they walk into CoC meetings as if they're coming to garden or for to club for a cup of coffee or tea. They have not been through the notice, through the minutes, etc. These are practical difficulties. We are not criticizing. It's a positive, maybe it may be taken positively to make officials more aware and come better prepared and to train them. And they don't have those skills which are required. And a typical M&A cycle also for a successful case takes at least 3 years. They are asking liquidation, CIRP to be done in few months without any preparation. This is practically very difficult and impossible. And the officials who don't take decisions make it more difficult. So these are some practical ground realities. If they are taken care of, the IBC code would be much better.
Right, sir. So now coming to the second one, which is regarding the CIRP cost, as to what all will form part of the CIRP cost, what are required to be evaluated by the resolution professionals, and on what basis this cost will be considered by the CoC. So certain clarity in this regard, we can say, or certain more kind of, we can say that some more burden being given to the resolution professional in this regard, so that we will discuss whether this particular proposal will provide clarity, is to provide clarity, or to raise further burden on the resolution professional regarding getting their cost or the CRP cost considered by the committee of creditors. So coming to as to what all constitute a reasonable CRP cost. We all know that duty of resolution professional is to protect and preserve the assets of the corporate debtor. There are provisions, there are regulations that provides the IRP to make every endeavors to protect and preserve the value of assets, and to put the cost before the committee of creditors so that the same can be ratified by the committee of creditors. So these are the basic duties of the resolution professional. We all know this part. But CIRP cost incurred by the IRP are reasonable or not, that is required to be evaluated by CoC. When we can say that CIRP cost is reasonable, when these are directly related with the CIRP process, when these are necessary for meeting the objectives of the CIRP process as provided in the code, when these are proportional to the work that is required to be done and the assets of the, and with respect to the protecting the assets of the corporate debtor, and these are determined on arm's length basis to in consonance with the requirement of integrity and independence, that these are the in general costs that were required to be incurred for the purpose of keeping some time keeping the corporate debtor as going concern, or maybe with respect to the process that the liquid is required to move ahead with, or with respect to the other other steps that are required to be taken by the resolution professional with respect to the CIRP process. However, it is ultimately on the CoC to see as to what all costs have been incurred by the resolution professionals and to take decision with respect to its ratification. Now coming to the concerns that are connected with the proposal, the current proposal that has been made. So the proposal says regarding going concern cost evaluation thing as well. So they want a GCA report to be prepared by the professionals. I'll just first read the language of the law. What is the language of the law? I'll just first read that part and then we'll come to the questions as to what are the potential questions that are arriving pursuant to the changes that has been introduced. I'm just quickly sharing the discussion paper. Yes, so I hope my screen is visible now. Yes, yes.
Ma'am, we understand that we have to actually give them the actual and the budgeted numbers side by side to the CoC. But then how about, payments happening also on time? Is there a provision where, our dues are also cleared within the time frame of a quarter or something?
I'm not getting clarity on what exactly you're asking. If you can please repeat again.
See, one of the earlier provisions that we were discussing, wherein you said
Yes.
that at the end of every quarter, the RP is required to provide the budgeted or the estimated expense for the quarter as
This
against
is
the
the
actual
current
expenses
changes.
incurred.
Ma'am,
What?
I'm sorry, I'm cutting you in between. So this is the current change. I'm yet to discuss that part. So this is the current change. I'll just discuss that part and then of course we will discuss about this thing as to
Sure.
what are the practical difficulties that may arise if we implement this changes, right? So this is regarding Regulation 31B regarding approval of committee for CIRP cost. Says that resolution professional may incur CIRP cost from a period commencing from the CIRP date up to 30 days from such date or date of constitution of CoC, which is also required to be made within 30 days. So whichever is earlier. So it is the first cost is from the commencement date till this formation of CoC, because till that time there is no one to determine as to what cost is actually going to incur. I am the person, the moment the CIRP process is admitted, I am there on job as a as an interim resolution professional. And certainly there are certain timelines which start clicking from the very same date as well. For example, with respect to making newspaper advertisement, collating claims, making list of creditors, etc. So these jobs are going on. And if the corporate debtor is also on the going concern mode, then I'm also required to make expenses towards that as well. So I cannot wait for the formation of CoC. These 30 days time that I'll have in hand, I'm required to make expenses. So whatever expenses I'm making in these 30 days, this first 30 days, these expenses I'll put forth before the committee of creditors. Once the committee of creditors is informed, and I'm required to ratify those expenses by the committee of creditors. So this is the first requirement. This was there as well, and this is a general practice as well. Now, the second thing says that CIRP cost incurred under sub-regulation 1 shall be limited to the cost necessary for preservation and protection, maintenance of essential services, compliance with applicable law, such minimal operations as are necessary to prevent value deterioration of the corporate debtor. So these factors are required to be considered by the insolvency professionals during this first 30 days. So first is regarding this 30 days expenses. While this 30 days, because there are no vigilant, there is no one to consult with regarding the cost that I will incur. So these factors I'm required to consider in mind while making the expenses. All the resolution professional cost incurred under this sub-regulation 1 shall be placed before the committee at its first meeting for approval together with the justification for such costs. So the thing here is I'm required to justify the respective cost, which is also in general, we make this as an insolvency professional, whatever expense we do, we generally prepare a particular list with the respective invoices and the factors to justify as to on what basis and what was the requirement of making those expenses. That also we place before the CoC to get their approval. Now the thing is, at the first meeting of committee of creditors, the insolvency professional shall place a going concern assessment report. Now the question is regarding this going concern assessment report. This requirement was not there earlier. So first question that arises here is, who will prepare this going concern assessment report? What will be the basis of understanding, or what will be the basis of preparing this going concern assessment report? Am I required to appoint a professional for preparation of this going concern assessment report as well? Because all the insolvency professionals may not have the expertise to prepare this kind of going concern assessment report. There may be a situation where the corporator is in going concern. There may be a situation wherein corporator is shut for, say, suppose for a certain number of period. However, has a potential to continue as well. Like, say, suppose there were machineries in the corporator and the plant is shut for a number of years. However, if some resolution applicants come up with tomorrow with a certain plan, put the fuel, put the money in the company has the capacity to run as well. So what will be the basis, or what will be the factors based on which this going concern assessment will be done? What all will be the recording of this going concern assessment report? So for this report, it's an inclusive thing which is provided here in the proposal. It says estimated income, expenditure, and cash flows arising from the continuation of operation. Details of working capital requirement, if any. Material risk of value erosion arising from the continuation or suspension of the operation. These are the factors that are required to be evaluated for the purpose of preparation of this report. Certainly, all the insolvency professionals cannot be expected to have the expertise on these factors. And during this first 30 days task, we all know that IRP or RP have so much burden to prepare, to collate the claims, then to verify the claims, then to prepare the IM as well. So can we expect the resolution professional to prepare this going concern assessment report separately as well for the purpose of this kind of evaluation, or for the purpose of getting the cost ratified by the CoC? So first question arises regarding this going concern assessment report. Then the second proposal which is there, based on this going concern assessment report under this regulation 4, the committee shall decide whether the operation of corporate data shall be continued, and if so, the scope and duration of such operation. So it is now based on this report, committee will decide whether to continue with the operation or to suspend the same or stop the same. So now this
Just one query, that this report only pertains to the first COC, right? If there is a
right.
case which is ongoing and
Yes.
multiple COC has passed, say 14, 15 COCs have passed, so now I'm not bound to place this going concern assessment report to the COC, correct?
So you are saying that this is not applicable retrospectively, but should be applicable prospectively. That is your concern here, I believe.
Yes, so my concern is,
Certainly, this is for the first meeting only, the first CoC meeting. So on the basis of which that will be determined as to whether to carry on with the cooperation of the corporate or not. So this is for the prospective. This change should be prospective only, should not be retrospective. Like the companies for which, say, suppose several CoC meetings have already happened. There in that case, I believe that this report should not be required. However, for the fresh cases, this going concern assessment report will be required. Second thing is regarding after the first meeting, the committee of creditors.
Ma'am, can I say something?
I'm just coming to you, sir. I'm just reading the provisions, and then I'm coming to you for your views on these changes. So the second is regarding after the first meeting, committee of creditors, all the insolvency resolution process costs shall be incurred only with the prior approval of committee. It says that after the formation of CoC, after this first meeting, all the costs that you will incur only with the prior approval of committee of creditors. So you have to prepare an estimation of the expenses that will be incurred in the coming future, and that estimation you have to place before the committee of creditors. Committee of creditors are required to give their consent for the same. Then only you will be in a position to make expenses. If they'll not, then you will not be in a position to make expenses in that regard as per the proposal that has been made so far. Then it says that for the purpose of Regulation 6, the resolution professional shall, at each meeting of creditors, place periodic estimate of statement of income, expense, cash flow statement for the period up to the next meeting. So you need to decide on the very first meeting itself as to when will be the next meeting, and till this time gap of first meeting and the next meeting, you are required to provide an estimate of expense that will be based on the statement of income, expense, and cash flow statement as well. And this will be like estimated thing that you are placing before the COC. You are required to seek the approval of the COC with respect to this IRPCP cost proposed to be incurred into till the next meeting, and place a statement comparing the IRPCP cost with the estimate. So, say suppose after the 30 days, you are placing a statement, you are giving an estimation of these all expenses will be incurred. In the next meeting, you are required to prepare a report. That report will be a comparative figure of what estimation you have given and what was the actual cost incurred. So you are required to give this comparative figure before the committee of creditors. So these are the changes that has been proposed with respect to CIRP cost. Now I'll just quickly ask the members as to what are their views regarding this particular change. Yes. Yes, Mr. Rajesh Seth, please make your submissions.
Yeah, thank you, madam, for giving me opportunity to express my view. First of all, this going concern report, your time given is only 30 days. And if it is a multi-locational company, it will be very, very difficult for even a resolution professional or even any other expert outsider CA firm who is expert in preparing this kind of report to visit all the locations and for all the locations give this kind of report. Then second thing, if any outside firm has to be engaged, who will bear the expenses? Whether how the prior approval can be taken for this kind of report for incurring the expenses, out-of-pocket expenses, or even their fees. And the time given is too short. That is what I wanted to say.
Right, sir. Rightly pointed out. So the
Madam,
thing is that
can I say
Can I
something, ma'am?
yes,
Can I
sir,
say
yes, sir.
something?
Yes,
Now,
sir, please.
there are two aspects. We are saying that within a period of 30 days, IRP is supposed to take the control and custody. He is supposed to constitute the CoC. He is supposed to collate the claims. Everything he is supposed to do within 30 days period. Not even 30 days, within 21 days, CoC needs to be constituted and then meeting needs to be convened. Now, the point is, when IRP is engaged with doing so many things, and even control and custody is not with him in most of the cases because he's struggling to get the control and custody. Promoters, management may not support, as we have seen usually in our experience. So therefore, putting a mandate on him that he has to prepare a report and put up before the CoC for going concern, my personal opinion is that it's too early for IRP to prepare and submit and present a report to the CoC. This is one. Now, the second aspect is that in most of the cases, what we have observed, the IRP may not be even regularized or appointed as a resolution professional. Maybe some other resolution professional is proposed by the CoC, as we have seen generally. And in that case, IRP is doing so many things. First, it is not practically possible. Second, he may or may not be appointed as a resolution professional. So he may prepare any report and put it before the CoC, which may or may not have a significant inputs at that point in time. So I personally feel that it's too early. Now, the first thing which is important is to take control and custody of the corporator. So once the RP or IRP or RP, as the case may be, is able to take the control and custody of the CD, only and only in that situation, he will be in a position to say whether the company can be continued as a going concern, company cannot be continued as a going concern. Without even getting the custody, how can we comment on that? It's practically not feasible and possible at all. So it should be linked with the control and custody. This is one. Second, there are provisions which talk about 19.2, wherein support and cooperation of the management is very important.
Cooperation of the corporate director, yes.
Yes, which is very important. And generally, what we have noticed that IRP or RP, as the case may be, within a month or so, is generally filing 19 to report even to get the basic documents. Even basic documents are not available in the public domain. The returns are not available. Balance sheets are not available. Just not there. So practically, it is very difficult. And even for 19 to notices, IRP or RP, as the case may be, he is supposed to issue notices under regulation 3A, 1, 2, 3, 4 notices needs to be issued. Once the notices are issued, then only 19.2 can be filed. And once the 19.2 is adjudicated by the court, only and only in that situation, order is given by the court under 19.3, and then the promoters and management can be held responsible. So I personally feel that in some situation the control and custody may be available, and in most of the situation control and custody may not be available. Even the basic documents are not available, what to talk of the control and custody of the CD and the assets of the company. So therefore, in a sum and substance, I personally feel that it's too early to say that going concern report has to be prepared, submitted by the IRP before the CoC. And another thing which is also very important, even the constitution of CoC may not be the final CoC within a period of 1 month. It takes a lot of time because claims are under collation, adjudication process is going on, a lot of information is being asked, collected. It takes time. So I think it's too early, too premature at this stage. This is all I have to say.
Yes, ma'am, can I
Also,
say something?
I would like to add, in case suppose as an IRP, I submit a report of going concern where I say that it is not feasible and the CIRP should not continue. What are the effects of it? Suppose tomorrow, if I'm not the RP, somebody else becomes the RP. Would they take my report as the premise to not take forward the going concern status of the company? If that is so, then it is against the IBC code, which clearly says that the going concern company should be kept as a going concern. There is no matter what my report says then. In that case, would there be any action against me?
Now
Very rightly, I think,
I
agree.
think,
pointed out by
I
Sandeep
think,
ji and Abhishek ji.
I fully agree with Abhishek. Now, the provisions which are given in these regulations are non-est in law because they are going against the code. Because code
yes,
giving a duty, there is a duty which is given to the IRP or RP that he has to maintain the company as a going concern.
I think, ma'am, can I say something?
Yes, please.
Hello, actually, there may be a provision that IRP or RP should try to prepare this statement. And the period may please be given 3 months at least, so that the statement can be done in a meaningful way. Otherwise, this statement, because in most of the cases, RPs that just have been pointed out, that RPs would not be able to take control and custody till the Form G status. Form G published, and in Form G also it is mentioned that RP is yet to take control. In that case, I think 3 months time may please be suggested in this case, that this statement may be RP may RP may try RP will try to prepare a going concern statement within 3 months. IRP or RP within three
So I
months.
think
Uh,
very rightly pointed out by Sandeep ji and Abhishek ji. I think Ranjan ji is also in concurrence with their view only that 30 days time is very short to have this going concern assessment done by the IRP. There are several factors to it. First is, of course, there is no certainty that IRP will continue as RP. And the second thing is, of course, that even in the span of this 30 days, IRP face different difficulties to even have the details of the corporate debtor in hand. So to give the assessment as to what all expenses will come up in future is very difficult. The other factor is also regarding this, that if say suppose the IRP is giving the going concern assessment report, and tomorrow it comes up with the RP, or RP tomorrow evaluates this factor that the going concern assessment report which was given by the IRP is not correct, or maybe the corporate is not in a correct position to continue as a going concern. So whose responsibility will it become? So there are several factors, and of course, the one of the major factor that this in this 30 days span of time which is given to the IRP, there are several tasks which are required to be performed by the IRP. So we cannot expect the IRP to again do us, to burden the IRP again with a different task to prepare this going concern assessment report, then to place the same before the CoC, and to have the estimate as well as to what all expenses are going to be incurred in the near future. So this will be too much of task to be performed by the IRP. There can be certain, like, some time span can be given. This role and responsibility should be given to the RP and not to the IRP, because of course IRP's continuation office as IRP itself is doubtful. So once the RP resumes office and once the CoC is properly concretized, properly formed, and to the factor that the IRP is getting the support from the corporate debtor that the IRP is required, only then this assessment kind of thing should be placed, or this going concern assessment can be done. But within a span of 30 days, or first 30 days only, having this assessment done is quite risky, as well as does not seem practical as well. Yes, Gauravji, you are wanting to say something. May kindly unmute yourself.
Ma'am, I had certain observations or opinions on this point. One, like the information memorandum and all itself, we have to prepare within 45 days, 54 days. We have been given much more time, and that is the basic information of the company. And now we are expecting this regulation, if it comes through, that within 30 days, you have to do much more than that. You have to first get the basic details and then plan for the future also. So those timelines are going for a toss, one. Secondly, during the entire CIRP, which runs into maybe a year's time or 2 years' time or 3 years' time on a practical basis, the scenario keeps on changing. So it does not make sense for having a going concern report only as a one-time exercise right at the beginning and then forgetting over it or sleeping over it. Because something that may be positive today may turn into a negative scenario going down the line, because you may not have interim finance or some other reason that may also be coming up. So it does not mean that one report at the beginning in the first 1 month, when you don't have the control, you don't have the custody, the promoters are absconding, the employees are not there, the data is burning somewhere or getting destroyed somewhere, lying in some unknown location. I mean, when nothing is there, you are busy filing 19(2), you are busy filing for custody and trying to take the charge of the company. It's impossible for an IRP practically to give a proper report for running the company as a going concern.
Right. If we practically see, so there can be a situation where, say, suppose there are no cooperation for the corporate debtor at all. In that
We are
case, of
talking
course, the
of a
concern
very
will arise.
utopian scenario in India's insolvency regime, that the promoter will cooperate fully, the data will come in fully, you'll have the cost sheets available to you, you'll have the visibility available to you for the sales, you'll have the visibility available for everything in the world, which will help you determine whether the company should be kept as a going concern or not.
So, like rightly you are saying, sir. So there can be two situations. I suppose the first situation is like I'm not getting any support from the corporator.
Which
There
is
are no data,
99% of the
nobody
case,
available to
ma'am. Which is
provide any
99% of
support.
the case.
Which is
99% of the
99% of
cases,
the case.
19(2) is filed by the RP or the IRP.
Absolutely.
Because
Absolutely. So in that
the
case,
promoters
it
do
will
not.
be completely impractical to prepare any report. The second, if say suppose I'm getting the data from the corporate debtor, in that case as well, say suppose there are several branches of the corporate debtor, several plans, say suppose plans, etc., are situated in different locations, etc. So again, it will be difficult for me to have a complete report in hand to understand as to what is the actual nature of the corporate debtor and what exactly I'm required to do with the business of the corporate debtor, how to, plan to sell the corporate debtor, invite the resolution plan, etc. So these evaluation to know the job of the corporate debtor itself is a task. at that time to have the estimate of the cost to be incurred into in the near future, or to prepare a going concern assessment report, etc., will be quite cumbersome. This is I think the crux of the discussion on this point.
Ma'am, there
Yes,
is another thing. There is another thing I may like to say one more thing. Considering all these factors, even the preparation of information memorandum, like Gauravji has just said, Regulation 36A, it talks of a period of 45 days and 54 days. Now, we are saying that prepare information memorandum today of the past scenario and prepare future projections, and that too within a period of 30 days without even getting the basic information is very, very difficult. This is all I have to say. And
absolutely,
it's
sir.
not
Absolutely.
possible at all.
Absolutely.
Madam,
Devang,
there
do you
have
want to
been
say something?
there have
Yes,
been
please.
Sometimes
there have been arrests also, or possibly criminal cases filed against resolution professional and CoC for industrial assets which are not properly maintained. This is the extent to which it can go. CoC will clearly say we have got an RP's report and go away. And if they want everything in control of CoC and RP responsible, better make the bankers as resolution professional. Why do you need IPs? The way in which IBC is going from 2016-17 till date, everything from domain of IP is going under the domain of CoC for decision making, but responsibility continues on RP. And these are serious questions. It is not just ordinary thing. Whether a going concern is to be there, maintenance is to be there. There are very serious
and
consequences
there
for
are
industrial assets.
yes,
And with due respect,
Devang
IBBI
sir, there are litigations also. Devang
company
sir,
and
there
2,000 crore rupees
yes,
company in the same way. There is world of difference between 2,000 and 20,000 crore rupees companies. Everything cannot be put in the
Devangji,
same way.
And
Devangji, I
I
understand the
would like to
concern.
add one more thing,
and
ma'am.
ma'am,
My practical experience says that there is a duty which is given to the RP to maintain the company as a going concern. Now, what we have experienced in the past, in certain cases, the CoC has passed a resolution that you do not continue the company as a going concern because they have given me a conflicting decision which is in violation of the code. I have gone to the court and I have asked the court, requested the court, kindly clarify my position. Court says that I have to maintain the company as a going concern. CoC is giving me a conflicting direction which is bounding on me under regulation 40A. And now you please tell me what should I do? Shall I close the company as a going concern or shall I continue the company as a going concern? Because there is a conflicting decision. So now another point which comes into the picture is that let us assume for arguments today that IRP says that company should be maintained as a going concern and he gives a best case scenario of the projections of the cash flow, etc. And CoC gives a direction, no, you do not continue the company as a going concern, close it. Can I close it? Now court says you have to maintain the company as a going concern. Now there is a conflict which has come. Now under this situation, court says you do it, CoC says don't do it. Then what do? I have to again go back to the court and ask the court, my lords, please give me direction. What should I do? So I personally feel that CoC cannot take a decision whether the company should be continued as a going concern or should not be continued company as a going concern, because there is a duty which is given under the code and RP is being made responsible for the same. So till such time the code is amended and it is in synchronization with what regulation the IBBI is proposing to make, there will be a conflict. This is all I have to conclude.
Madam, I would like to submit one point. The
Yes, sir,
first,
please.
our discussion should be confined with the proposed changes in the regulations. Let's see the problem statement what IBBI has stated. IBBI has stated as per a problem statement, they are on the view that CRP, if the going concern status are maintained, the company incurred the losses and the detailed informations are not provided, and RP seems to be continue with the operations, and because of that, value of the companies goes down. This the statement looks appear. Now, in nowhere IBBI has stated what is the meaning of the going concern status and non-going concern status. If the project is closed, lying closed, and there no operations, then it means there is no revenue generation. Then to my mind, company is not having at going concern operations. Then your requirement to giving the projections and the cash flow statement arises only when company has the operations. It means revenue generation, cost of the operations. Now, you can give the RP can give these projections in 30 days, provided MIS are available for the relevant months for the past 2-3 months. If the company is not having the relevant MIS means the financial information about the sales, cost of operations, running cost, cash losses or cash losses, what is that there? How RP can give the financial projection to the company. As for this regulation requires only the estimate regarding the going concern operations. As regard the normal CRP cost, suppose voting cost, something like that, RP fees, valuation fees, I think no projections are required and no prior approvals are required. This prior approval is only for the maintaining going concern status. And this information can be made available only when your MIS are available, which sometimes may be available if the company is meeting entire records. Now, second problem what arises, suppose company's records MIS are available for the previous month before the CRP commencement date, and company is showing company incurred the loss of cash loss of 30 lakh rupees on the sales of 10 crore rupees. Is this information, if we submit this information the CoC, can CoC decide, okay, please discontinue the operations? To my mind, certainly not, because this is a very small analysis. A company is making the loss of 30 lakh rupees. Now, second analysis, what requires, which most of the RP will be unequipped to do and analyze the data. If we discontinue this operation, my cash loss may increase to 50 lakh or 60 lakh rupees, because I am going to continue to have the electricity connections where you have to pay the minimum wage, minimum rent. You maybe have to pay the rent charges also. There are many fixed expenses which you are recovering because you are maintaining the going concern status of the company. But once you discontinue the operations, this all expenses will be lying unpaid, which you make your losses more. So for making the decision of the going concern status, whether to maintain the company as a going concern status or no, much more deep analysis is required, which RP may not be equipped to handle those cases and may not be possible in 30 days time. That is the genesis of the problem. Number two, now what is the meaning of the going concern status? I give the one example in the real estate project. The project has 14 towers, 5 towers are running and 9 towers are lying incomplete. In 5 towers, you are getting the maintenance expenses, you are incurring the cost. Now, is this project is going concern status, having the going concern status or not? It's very the clarity. Because here you are drawing maintenance charges from the residents also. And you are paying the maintenance cost also, trying this one. And they may be at the end of the day, you may be having 1 or 2 lakh or 3 lakh rupees plus, or you may be having 1 or 2, 3 lakhs minus. Nobody knows. So how you can decide whether this company has the going concern status, yes or no, and can RP or CoC can decide, please discontinue this going concern status and ask this all home buyers to get away from the project? Certainly not. So these clarities are more required. What is the meaning of the going concern status here? And one more analysis is required whether these are feasible or not in 30 days time. That is the most important things. It is very simple statement. You submit projection. Projection you can submit and there is no bar. You can revise your projection in next CoC meeting. You can always say, sir, this is my projection and this is the new projection, new information has come and this is my new projection, and you decide accordingly. That is not the fix. But problem is something different.
Very rightly said by you, sir. In fact, that
Ma'am,
was the
can
point
I would
that
like
other
to add
participants
last
were
can I
also
thing.
making.
propose one thing?
I would
Can-
I would like to add last thing, but Pavanji has said that in the case of real estate projects, ma'am, even the RP has to appoint the engineers to assess the cost, what is the cost which is likely to be incurred for the project, and after doing the proper assessment, details, then only the outflow can be projected, then inflow needs to be projected, and experts take a lot of time to do this analysis, which RP is normally getting it done. It may take 2 months, 3 months, whatever time it takes. And now, if IRP is supposed to do it, then within a period of 30 days for real estate projects, like Pavanji has just said, it is too complicated. And We are not differentiating one CD with another and with another. We are not doing that. It is not based on the nature of the business. We are making a general thing that you have to do it. So I think practically it is very difficult within a period of 30 days to carry out this exercise. And if this exercise has to be done just for the sake of doing it, then that may not be right and appropriate. So there are two things. One is a legal challenge and second is a practical difficulty.
Absolutely, sir. Absolutely.
Madam,
In line with
Ma'am,
what you
ma'am, can I
suggested.
add
Yes.
they
something?
have done
Yes,
CEP
Gauravji,
studies.
please.
Ma'am,
They have
in
done
my
kind
view,
of, they have done
first of
CV
all, I'd like to
studies. They
differ
have
from
been focused
everybody
on
that
lot of
the
Devangji,
things.
I'll come back to you. Please, I'm just allowing Gauravji for the time being to make his submission, then I'll come back to you as well. Yes, Gauravji.
Ma'am, here I'd like to differ from everybody that the IP is not capable enough to do this kind of a report. My only challenge is the time frame that we are being expected to do this without having the proper information in hand. We cannot take incapability as an excuse for not being able to do the role of an IP, whatever has been asked for us to be done by the authorities. When we started IBC, we were not capable as IPs also, but we learned and we performed and we are doing a good job according to me. For I don't know everybody's views, but I feel we are all doing a good job as a community. And even this week, most of us would be having the skill set. And even if somebody does not have the skill set for a case perspective or case specific perspective, we are capable enough to get things done. The role of an IP is to manage the whole thing. It is not for him to do on its own. For legal, you go for the legal counsel. For valuers, you go to the valuers. For audit, you go to the transaction audit. You are not expected to do everything on your own. Your role is to ensure that you get the entire ecosystem going and get the things done. So this is another responsibility that is being thrust upon you. You have to do it. You have to do it. My only
Which
concern
is
that I
correct,
was
Gauravji, but I think that you are also aligned on this particular line that to have this report in hand within a span of 30 days is quite
I agree
difficult.
with you. My concern is not about whether you can do it or not do it, but my concern is the time frame and the
Time frame of
expectation
30 days,
that is
yes.
being
And the second, I
thrust
think
upon.
the point that was validly raised regarding this continuation of IRP as RP and the assessment to be done by IRP, that is also a very valid point that if IRP is making the evaluation with respect to the going concern status and ultimately it is the RP who's a different person, say suppose a different person and that person is required to carry on with the job, then of course this assessment to be done in a prelim stage by the IRP should may not serve the purpose. That is also a valid point here. And then to first, of course, this span of this 30 days time is quite short to have this report because there will be quite a long list of tasks to be performed by the IRP, including the given task which is already there in the provision. If we add on the further tasks regarding the preparing the going concern assessment report, then having the assessment of the expected expectations, expected expenditures to be incurred in the near future, and the statement of the cash flows and expenses and income to be that incurred by the RP during the span of 30 days time, etc. So that will be quite cumbersome task for the IRP to perform. So of course that I think this we all are aligned on this line that this time span of 30 days is not accurate. And if at all the going concern assessment report is required, then the basis on which this report will be prepared, certainly not by the IRP, but the RP at a later stage. But on what basis this report is to be prepared, certainly the basis of those reports or some kind of factors to be considered for the purpose of making this report. There can be, of course, a situation that RP himself is preparing the report or RP is taking support of any of the professionals for the purpose of preparing the report so as to have the more accuracy or more validity or more reliability of that report in hand. So that is certainly up to the RP and can be done by the RP.
Barsaji,
So
one more
this,
thing I would like to add is
yes, sir.
one more major input that an RP needs to consider whether to decide whether the company should be kept as a going concern or not is the fact that it will have an impact on the valuation of the company when you try to sell the company, and whether that impact is acceptable levels or not is something that only a expert valuer who's been appointed can point out. It is not up to the RP to have that skill set to say, okay, the valuation will take a knock of say X percentage and put it up to CoC that, okay, you take a call whether you want to incur this kind of losses or you want to incur this kind of loss in the valuation. So that unless the valuer report is on table that this is the kind of scenario which will happen if going concern is shut down and you then have to sell the company as a slump sale or the asset sale,
till you don't have the report in hand, you cannot take a call on that whether you should keep it as going concern or not.
The requirement of appointing the valuers comes within the period of 30 days itself. So
No, ma'am,
certainly
valuer appointment comes after 30 days.
No, so
No.
the requirement of having the valuers or to have the report from the valuers or to have the professionals, that will also be the job of the IRP or RP as the case may be. So say suppose if they are having this report, going concern assessment report within the span of 30 days itself, so that will certainly impact the valuers report as well, as rightly mentioned by you, Gauravji. So this, of course, this assessment has to be done with proper clarity in hand. Devangji, yes, coming to you, may please unmute yourself and say whatever you want to submit regarding this.
Yes, madam. Madam, besides the timeline, the challenge of availability of data, not only from the management side, but even from the banker side, who would have surely done TV study at the time of sanctioning and disbursement of the loans. And then yearly profitabilities and analysis of monitoring would have been done. But do we get that data from the bankers? No. And were they sleeping after giving the loans? I believe most of the bankers are fully aware of the viability and what is going on. But unfortunately, they
Devangji,
don't come to the CoC
Devangji,
meeting.
I'm sorry, I'm cutting you in between, but the thing is that I do understand the concerns that you have, and I believe that all these concerns are generally in other CIP matters as well. But currently, we are just focusing on the proposed changes that has been proposed by the IRP, by the IBBI. So I would just request you to focus on these changes for the time being.
Madam, we can suggest that we get the data also from the
So
other
if you
CoCs.
have any input on the changes that has been proposed, whether to go with the changes or to have certain kind of clarity, etc., on the changes that has been proposed, you may kindly submit in this regard.
Madam, I'm saying regarding the same itself, why can't we get the data from these people? That would be great help. Our teamwork would be great help. So if that could be suggested, if we get data and intellectual inputs even from that side, that would be great thing. Second thing is,
Noted, sir.
madam. Second
Noted, sir.
thing is,
Yes, Ranjanji, you are also saying something. We kindly unmute yourself and submit.
Yes, ma'am. I can say that this may be clubbed with the preparation of IM, which require 95 days. And in this case, there should be a note by the RP. It may be proposed that whether this only there may be a note that whether this company can be continued as a going concern or not, along with that IM. So this should be this may be clubbed with IM. IM is actually would have to be shared with the CoC within 95 days. So in that case, it makes more sense.
Noted, sir. So now I think we have a fair idea of what the proposal is and what the concern of the respective IPs are. Now we are just quickly moving to the remaining 2 points. I'm just sharing the screen. So the next change is regarding the say of CoC in case of delayed claims. I believe my screen is visible.
मैम expenses part में भी कुछ है जो बहुत ही
I'll just come back to you on that part towards the answer. Just
Yes.
allow me some time because we are running short of time. So I'll just quickly move to the remaining
expenses
changes. And
part
then, of
are
course, we'll
very
discuss.
important, ma'am. ठीक.
Yes. So the clarification on the role of CoC in respect of delayed claims. So it is a clarificatory thing. Earlier as well, the law provided as to what will happen in case of delayed claims, like within the 30 days time, if the IRP or the RP has not received the claim, in that case, how to deal with the delayed claim. So the law was there earlier as well. Now it's just a clarity which has been provided. So it says that put up the claim categorized as acceptable under sub-regulation IB and collated by him. First, these delayed claims are required to be placed before the adjudicating authority within a week of receipt of such claims for condonation of delay. And once it is condoned, thereafter it is required to be placed before the CoC. So this provision was there earlier as well. It is just the clarity has been provided that first, of course, condonation is required, and once the delays are condoned, then only the condoned claims are required to be placed before the committee of creditors. However, there is one concern which is regarding this particular line that says before the committee of creditor in the next meeting for its recommendation for the treatment in the resolution plan, if any. So this treatment in the resolution plan, if any, this line was there earlier as well, in the earlier provision as well, the same line was there for the treatment in the resolution plan, if any. However, my humble submission here is that the treatment in the resolution plan, what will be the treatment of a particular creditor in a resolution plan, this cannot be decided by the committee of creditors. Committee of creditors may decide on whether or not a particular plan is acceptable to them or not. However, what will be the treatment of the respective creditors, that cannot be decided by the committee of creditors. That has to
Madam,
be, the treatment has to be in line with the treatment of the same line of creditors. So that certainly cannot be decided by the committee of creditors. This is what is my submission. However, this particular changes is just a swift of the provisions which were there earlier. The first condonation by adjudicating authority, thereafter to place the same before the committee of creditors. Yes, so I'll quickly ask the members if they have anything to say.
yes, madam. Now there are
Yes.
two aspects. I would like to clarify it very, very carefully what I'm going to speak, because I had already discussed this issue with the IBBI at some point in time. Now, when the earlier provision of section 13(1)(c) was introduced, now at that point in time there was no provision of condonation of delay for the claims, 90 days or RFRP, and then window is over. Now anybody and everybody was going to NCLT to get it approved, and then a lot of litigation was pending before the court. And so to cut the litigation short, they introduced regulation 13(1)(c), wherein they have introduced it that if the claim is not submitted within a period of 90 days or RFRP, which is the starting of the window, and closing is the resolution plan approval, CoC 7 days before that, or liquidation order. Within this window, the claim has to be, if claim is received by the RP, in that case, he will verify. If it is not acceptable, then he will reject it. And if it is acceptable after verification, he will put up before the CoC. CoC will give its recommendation, and then he will take it to the NCLT for approval. This was the earlier provision. Now, there was an ambiguity at that point in time as well. Now it says, if we read it, which is in front of us in the screen, put up the claims categorized as acceptable under sub-regulation 1B and collated by him to the committee in the next meeting for its recommendation in the inclusion. So what RP was supposed to do, what he is supposed to do even today, according to my view, that whenever any claim is received which is belated in nature, he has to take up to the CoC in the next meeting for recommendation. And once it is recommended, he has to file an application before the NCLT for condonation of delay. This is what is being done now. In the proposed resolution, in the proposed amendment in the regulation, what they are saying, that he has to take it up before the adjudicating authority within a period of, I'm missing it, I think it is 7 days. I'm missing that. It is 7 days.
Yes, that's
7 days of receipt of the claim. Now what he will do, he will, after 90 days, he will keep on receiving the claim, because home buyer claims keep on coming, and it continuously comes. So every month, I believe, within 7 days, he will filing application, and he will be filing 10 applications before the court. He has to do it because it is a mandate which is given within 7 days. You have to file an application. He will continuously file. And what will happen? There will be piles of application which will be before the NCLT, which they have to approve or condone. What was happening earlier? Same thing was happening earlier, because the claimant were filing the applications. Now RP will be filing the application. The difference is that today it is a verified claim by the RP. This is the difference. It is only the condonation. So this is one thing. Now the second aspect in the proposed regulation is that he has to take up before the committee in the next meeting for recommendation for treatment in the plan. Now, why are we saying that? There is a reason for that. Because if a new claim comes, there are two things which are going to happen. One, there may be change in the constitution of the CoC, because if NCLT condones a delay in the claim, then if a new claimant comes which is a financial creditor, or maybe an operational creditor for that matter, home buyers cases are generally the troublesome one. There will be change in the constitution of the CoC, so they will form part of the CoC once it is condoned. So he has to reconstitute the CoC RP once it is condoned, and then he has to take up before the CoC. Now two things are going to happen. One, the information memorandum which has already been issued under regulation 36A will change, because claims will change, claimants will change, composition of claims will also change. Since under regulation 36A, there will be change in the information memorandum. So based on that information memorandum, the SRA is giving a resolution plan. This is how the sequence is, because RFRP comes under regulation 36B, 36A, 36B, and then resolution plan comes. Now the resolution plan comes, and the proposed resolution applicant is expected to go through the details given in the information memorandum, and based on that he has to propose the payment in the plan. So now if claims are going to change, some financial creditors will come, operational creditors will come, or whatever the case may be, then SRA is supposed to cover all these things in the resolution plan. He has to do that. Now, how will he do it unless the information memorandum is amended? Because information memorandum needs to be amended. Who will amend the information memorandum? CoC has the power to do that. So I think the logic is that CoC has to take requisite steps by giving a direction to the RP. Okay, to this extent, new claims have been received. So information memorandum needs to be changed, amended. Amendment may be issued, details may be shared with the proposed resolution applicants, so that they can take it in their resolution plan. I think this is the sense which is making from this second one. More clarity is required. Clarity is not there. This is what my view is. This is how I assuming this is how it is going to be. So
Yes, yes,
I
sir.
think this
In
is the
fact, I
logic
also
of
believe on this
can
front that there
yes,
should be certain limitation of time till which claims can be submitted. It should not be till the resolution plan is received. It should be a certain time limit up to which the claims can be received, because of course during the CRP process as well, the entire evaluation of payment towards a financial creditor, operational creditors, etc. is required
No,
to be
that is
done.
already given,
And
madam. That window is already given, because that window is given in prior to that, and it says 90 days RFRP, or the CoC last date up 7 days before the date when the resolution plan voting has to take place. That is the window which is being given, and within that window,
so that is again is till the time that you are waiting till the receipt of resolution plan for the purpose of
no,
accepting
no,
the claim.
plan is
So
already received. Voting has to take place on that plan even
voting,
7 days before that CoC meeting. Now there is another ambiguity which practical experience says, which I have faced practically, which I did discuss with IBBI, and probably they also didn't have the answer for that situation. Now what happens that suppose claims are received up to 7 days before the meeting in which the CoC has to approve the resolution plan. That is the window available for the RP. If now claims are received beyond that, because resolution plan is approved, voted upon, and then plan application is filed before NCLT for approval, which takes a lot of time. And suppose claims are received after this CoC meeting, then RP cannot do anything. Technically, he doesn't have any power to do anything. Now he will not do anything. He'll keep on compiling the claims, whatever claims are received, and then claimant will go to NCLT to take the direction from the court. One scenario. Second scenario, what we have practically experienced, that in some situations the resolution plan is remitted back by the NCLT for whatever reasons. If the resolution plan is remitted back by the NCLT, and it means the window will again open up. If window will again open up, it means the last CoC meeting in which the voting take place, which is the final resolution plan approval meeting. Till that date, the window will be open. So in my example, if the new claims are received after the first one, then those also needs to be dealt with, because we are practically facing this situation in the court. Normally appeals are being filed because NCLT sometimes say rejected, then they go to NCLAT for these situations. So NCLAT says, no, what are you doing? You have to consider it, because there is an ambiguity. So now probably has to be a clarity, which CoC meeting in which plan is approved, first one or the last one. Clarification is required. So that is not there, but the
absolutely,
courts are considering
absolutely
it's the
rightly
last one.
mentioned.
So window
Yes,
keeps on
yes.
open, close, open, close, open, close. This is what is happening.
In fact, we have also seen in several of our cases as well that there is no end date up to which you are receiving the claim, and that you are keep on receiving the claims. And in fact, the judicial bodies are also of the view that since it is not finalized yet, you are bound to accept the claim. So there has to be a clarity in this regard as well, as rightly mentioned by you, sir. Yes, I'm coming to Yogesh ji for your submission. Yes, Yogesh ji, you may please unmute yourself and make submissions. Yogesh ji, are you there? I think he's not there. Okay, Rajesh ji, are you there?
Madam, my simple question is, while we are discussing all the provision, how we are going to communicate this, whether this will to the concerned IBBI people, and whether this will be taken care of or not. I just want to have simple query about it.
So the very idea of the proposal is that only, sir, that these are the proposals, and if IPs have their practical experience and if they have something to say in this regard, we are having this discussion. We will jot down all the respective submissions by the IP that has been made, and will submit the same before the IBBI. And certainly that is up to the IBBI to evaluate the same and to make necessary changes in the provision that they think will be correctly suited. So they will accordingly make changes in the provisions.
We will submit to the IBBI, they
Yes,
will
madam.
submit to the consent committee, and then they will submit that will.
The timeline is given in the proposal itself, sir. It's 10th of March. So certainly after this meeting, we will make the necessary changes, necessary edits in the proposal front, and will make submissions to IBBI.
Okay, thank you.
Madam,
Yes, sir.
thank you very much for giving me opportunity. First of all, I would say that while framing this proposal, it is not been taken into account various kind of CIRP processes which are already completed or maybe in offing. I have handled a CIRP case where there were 16 lakh claims, out of which 10 lakh claims admitted. And every day I was receiving more than 3,000 claims. So by this, if I have to every day one week is over, and even after the last deadline, hundreds of claims, lakhs of claims I have received. So does it mean that every day I have to rush to the court to just to comply that 1 week timeline? So this is not at all feasible. What is written here? Not at all feasible. And second thing, even after the expiry of approval of resolution plan by NCLT, I keep on receiving new claims, and not even by financial creditors, but by even government authorities, that is the Provident Fund authorities, GST, and where the claims are huge in crores of rupees. So how do we deal with this kind of situation, which is not envisaged by the whoever has made this? Then even the home buyers case, home buyers also large in number. In many cases, one case I have handled where home buyers are more than 1,000, and always there will be some few cases, maybe 100, who are gone beyond the deadline. Then how do we handle these kind of cases? And second thing, even if they are classified as acceptable, and what impact it will have on a resolution plan, because RA resolution applicant, will he be able to do justice to such a large number of claims, and by number as well as the amount? Because operational creditor, particularly government authorities, they never submit the claim in time, and they always submit after the due date, and they want due consideration in the resolution plan. So whether resolution applicant is willing to do all these changes in the plan, and whether existing CoC members are ready to take a haircut, because whatever is earlier submitted by RA, this will definitely be reduced in the recovery if the delayed claims are accepted. So once again, this is a loop. It is a continuous loop which will go on, which is impracticable. So this is my submission.
Well noted, sir. Now coming to the last one, last
Rajesh,
part.
I have a query. I have a query. So,
Yes.
in case, ma'am, anyone can answer this. So, in case what happens that a claim comes to me at a belated stage, and whereby it is on RP as well, but it is also the responsibility whether there is any responsibility of the claimant when RP has responded to him that your claim is at a belated stage. Now the plan is up for voting already. So you go to NCLT, get the directions from there. But the claimant never goes to NCLT. Once the resolution plan is approved from NCLT, it has been implemented, all the monies have been distributed. Now the claimant goes to NCLAT directly against the RP. So in that case, I'm still stuck in one of the matters where the SRA is the party, the claimant is EPFO department, and from RP I'm there, but I'm stuck there. Ma'am, you are on a mute.
Yes, I'm sorry, I just lost you in between. So if you can please repeat yourself.
So my query is that most of the time it happens that RP responds to the claimants that you can go to NCLT and get an order if you're coming at a belated stage. Like in one of the matters, EPFO department submitted its revised claim when the plan was up for voting. And I have responded to them that you can go to NCLT, get an order. Only then I'll be able to consider it at this stage. But EPFO department never went to NCLT. Then, when the plan was approved by NCLT, the monies came in, implemented, distributed. Now, EPFO department goes to NCLAT against the RP as well as SRA, saying that during when the CIRP proceedings were ongoing, EPFO proceedings were parallelly ongoing. We have given the notice earlier prior to CIRP, but the proceedings were ongoing and order came in late. So what should I do in that stage as well? Because according to the proposal in DP, I have a very limited window to go around it.
Regarding EPFO claims, sir, I believe that this issue, I think we all have faced with respect to statutory dues, that they come up later, they come up with a later stage of the CIRP process or even in liquidation stage, and then they say that parallel proceedings were going on and their dues were not considered during the process by the IRP or RP. These issues, I think we all are facing some or the other way regarding this.
Am I audible now?
Yes, sir. Yes, you are audible.
I think regarding the EPFO issue, there is already a Supreme Court decisions, and every SRA has to mention in the resolution plan
Right.
that they have to take care of the EPFO dues, whether it is the claim is filed or not filed.
Yes, absolutely. So I was
So
just coming
I
to
don't
that
think there
point
should be
only,
an
that
issue on that.
during CIRP process, sir, you, in fact, during liquidation process as well, you are not required to
Correct.
wait for the claim to be filed by them.
Right.
You are required to consider the claim irrespective of the fact whether the claim has been filed by them or not. So that is a factor. So even if you have not considered the claim at the later stage, then of course I think NCLAT will also direct you to that direction only, that you are required to accept the claim of the EPFO and accordingly are required to make the respective provisioning regarding their
In
dues.
fact, it
So
is
that is,
mentioned in the resolution plan itself that
yes.
they have to take
So
care of the APFO claims if it is not filed. If it is filed later on, they have to make payment of that. So that is the, I think, the as of the position as of now. Now my point was regarding the claims. I think this filing of the application with the adjudicating authority is creating a unnecessary issue because everybody is filing multiple applications, as has already been pointed out by Mr. Sandeep Vij and the previous speaker as well, that they are receiving on day-to-day basis. So I think this requirement is not should be changed, because for every application we know the working of the NCLT, how much time it is taking to adjudicate any application. So I think if it can be avoided, this part can be.
particularly the condonation of delay matter, rightly mentioned
Yes,
by you, sir, that on
this
one
is,
hand we are saying that NCLT's burden should be reduced in these
yes,
frivolous
I
application.
think
On the
this,
other hand, we are giving this kind of provision, or we are making this kind of provision wherein we are necessarily required to make application before the adjudicating authority for accepting of or condonation of delays kind of
right.
application. So
I
this will
think
unnecessarily will burden the NCLT, will take time of NCLT towards this frivolous application that can otherwise be done by the RP with the consultation of CoC, etc. So that of course that is a correct point made by
I think
Yogesh
it
ji.
should be left to the COC to accept it or not to accept
Absolutely.
it. It should not be like approaching the adjudicating authority for their approval or for condonation, whatever it is. I think this part need to be removed.
Now coming to the final proposal which is there, so it is regarding the formation of CoC only. So we all know that when there are no financial creditor, then operational creditors are required to form the CoC. However, for the financial creditor, law clearly says that no related party will form part of the CoC when it comes to financial creditors committee. However, this line was not there for the operational creditors, so they are just aligning this part that the related parties, the operational creditors who are related party, will not form part of the operational creditors committee. So it's
Please move
just
the
a
PPT also, madam.
sorry, sir.
Please move the PPT also.
Right, sir. Right, sir. Just so it is regarding exclusion of related operational creditors from CoC. So it is just a clarificatory part that says that uh, this expressly says that related operational creditors should not form part of the CoC. This is in line with what is there for the financial creditors. Now, again, same questions. What if all the operational creditors are related party of the corporate debtor? So these questions are again, I think, should not be a big factor, because if that be the case, then certainly this the question of IRP-CP provision itself will not arise. Why will related operational creditors will raise or will make application for the CIRP process? So this question may not be relevant here. However, I think this is just a clarificatory part and did not need some kind of detailed deliberation here. So
But I
that is
think
the
a
only.
related party can file an application under section 7 or 9.
Of course, certainly they can file. It is not about Section 7 things, sir. It is about operational creditor. So when it comes to operational creditors committee, so it
But even
certainly is a
section 9
situation wherein there
application
are
can
no
also be
financial
filed.
creditors at all.
Can a section 9 application cannot be filed by a related party?
No, application can be filed. So that is what the provision is saying, that they should not form part of the CoC. They should not vote on the particular agendas that will be discussed, because of course there will be a question of having some kind of partial views. It's very similar when it comes to financial creditors thing. So, like, we are not saying that related party financial creditors cannot file the application. However, the question is, why will a related party financial creditors will file an application, particularly for the CRP processes of the corporate debtor? They will certainly make some kind of settlement, and if settlement is not possible, certainly they will, if at all the situation will be such that they will find that the settlement is not practicable, etc. In that case, of course, they can move ahead with the application under Section 7. Similarly is the case in case of operational creditors as well. Like operational, if say suppose there are no financial creditors, then CoC will be formed by the operational creditors. And if it is the CoC is formed by the operational creditors only, then RP should not be part of the CoC. So it is in line with the general provision for the financial creditors committee. So I don't think so that requires detailed deliberation here. So this is all about the changes. These 4 changes for the time being are proposed,
Ma'am,
and
there was one expenses part.
yes, sir.
Please
Yes,
discuss that.
sir. Ranjanji, I'm coming to you. You may please continue with the expenses part quickly, and then we can finish today's session. Yes. Ranjanji, you may please continue regarding the expenses part that you wanted to submit.
I have one point on this issue, proposal
Can you
3. The filing of the application within 7 days is very cumbersome. Because if you don't know whether today one claim has come, after 5 days another claim comes, how many application RP will file? Ultimately, if we so
Pavanji, I'm sorry I'm cutting you in between because we are running short of time. So this we have already discussed that the 7 days time is too short. In particularly in cases wherein home
can
buyers are
you
involved and all, wherein we are receiving lots of claim in a particular day. So 7 days time will be too short. That we have already noted. Ranjanji, if you can
can you
quickly.
please show the relevant proposed provisions? That is, there were three provisions that you have shown earlier.
Yes, I'm showing this.
Earlier, the burden was on the claimant. Now it has been shifted to the RP. So RP is already overburdened. Why it is shifted to RP for this condemnation?
It was in your slide, man.
Parsaji, that was
Just a
exactly
second, sir.
my
Just
point.
I'm just
If somebody is delaying the submission of claims, then he should be the one running to the court. He should be bearing that cost. Why is that botheration or extra duty being put on the RP? Why is the RP being made to be penalized for somebody else not doing his task in time?
You are
Yes,
right, sir. In fact, that is the part in case of
yes,
liquidation as well. In case of liquidation,
this is
when
one.
the
Yes.
claimants are required
After
to
the
make
first
application for
meeting,
the
yes,
proper.
yes, ma'am. Please go to the point number 6. Point number 6.
Yes, sir.
After the first meeting, all insolvency resolution process costs shall be incurred only with the prior approval of the committee. That is, the present situation is that one budget we get approved in the first meeting, and uh, whether the IRP would be confirmed as RP. He gets one budget that yes, for 6 months, these are the recurring expenses because there are litigation, there would be security expenses. So these things are recurring expenses. Now going to the point number 7, can you please scroll up? For the purpose of the resolution professional shall at each meeting of the committee place. Where is that? Please go to
Ranjanji,
that.
this we have already discussed that what all is required to be placed before the committee of creditors and how to get
But
their approval.
in each
So, what is
every
the concern? If you can
yes,
directly
in
go
each
to the
and
concern
every
part.
meeting, the first meeting, the budget has been sanctioned, and after that, this regular expenses, recurring expenses per month of litigation expenses, security expenses, if that would have to be get approved again and again, then that will put the RP in a very awkward situation, and RP we generally have to attend through his advocate many litigations in high court, in district courts, in other tribunals, TDSAT. Yeah, so if so one advocate has been usually being appointed by the RP to take care of all these, and there are security expenses also per month. Like this, there are recurring expenses. So these recurring expenses would be made out of this purview. So recurring expenses, as per budget approval in the first meeting, should not be part of this approval process in each and every meeting. That is my proposal. That is that
Noted, sir.
rectification
Noted.
need to be done.
Right, sir. Noted.
Otherwise, RP and number one is another thing. There may be some point that CoC would also try to disburse the approved expenses to keep the process going. This may also
Right.
be added.
Well noted, sir. I've noted your points. So, noted points of all the IPs, those who have put forth their thought about the proposal that has been made, will certainly prepare a respective draft with respect to the proposals and the changes that IPs are proposing, and accordingly will place same before the ICSI.
Madam, one small suggestion. If
Yes, sir.
discussions rather than in silos, if all stakeholders could come together and address each other's concerns, that would be a better way of dealing so that we work as a team. So, a small suggestion.
Right, sir. Thank you so much, everyone, for your time,
Madam,
and thank you so much for
Madam,
having
can we
interactive
receive
discussion.
the presentation? Madam, can we receive the copy of presentation?
Sure, sir. I'll share the copy of presentation. Thank
Okay,
you so
thank
much,
you.
everyone. Thank you.
Thank you.
Thank
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 you
you,
so
everyone.
much.
Thank you, Barsha. Thank you, everyone.
Yes.
Thank you, madam.
Thank you, ma'am, and thank you all the participants for giving your time and sharing your suggestions on the discussion paper.